What is discovery for a DV allegation in family court? Imagine trying to piece together a puzzle with missing pieces. That's what discovery is like in family court when domestic violence allegations are involved. It's a process where both sides share information and evidence to clarify what really happened. Discovery helps the court see the full picture, not just one side's story. In domestic violence cases, discovery allows each party to request documents, ask questions in writing, and get testimony from the other person. For example, you can ask for text messages, emails, or photos that might show what actually took place. You can also request police reports or medical records if injuries are involved. These pieces of evidence can be very helpful in proving or defending against allegations. One common method is called interrogatories. These are written questions that the other person must answer under oath within about 30 days. They often focus on details about the incident, the relationship, or previous incidents. Another method is requests for admission, where you ask the other side to admit or deny specific facts. If they don't respond within the set time, the court might accept those facts as true. Requests for production of documents are another tool. You can ask the other person to give you copies of texts, emails, photos, or medical records. Depositions are also used, where a witness or the other party answers questions under oath outside of court, with a court reporter present. This helps prepare for trial and preserves their answers. Sometimes, you might need records from outside sources like police departments, hospitals, or employers. Subpoenas are used to get these documents if the other person refuses to share them voluntarily. However, there are limits. A new law that started in January of 2020 restricts discovery in domestic violence cases. Courts need to see a good reason to allow discovery, because these cases often move quickly. The hearing must happen within 21 days, so traditional discovery methods might take too long. This law aims to prevent delays and protect victims from abusive tactics. If you want discovery, you must show the court why it's necessary. This can be done through a written request or during a hearing. You need to explain how the evidence relates to the case. When responding to discovery requests, you can object if they are too broad or seek privileged information. In practice, if you're facing a domestic violence allegation, understanding discovery helps you gather evidence to support your case or defend yourself. Be specific with your requests, focusing on relevant details like dates, communications, or medical records. Timing is key, so act quickly. Working with an attorney experienced in family law can make this process smoother. They can help you draft requests, respond properly, and present your case effectively. Discovery is a vital part of family court because it helps ensure that the court gets the full story, especially in sensitive domestic violence cases.